Counterfeit products are estimated to cost the global economy $250 billion a year. This includes counterfeit pharmaceuticals and healthcare products. What risk does counterfeiting pose to American companies? That's today on Liability Watch. Welcome to Liability Watch. I'm Shelby Neal. Counterfeit products pose a variety of problems for companies. In addition to raising serious health and safety issues for consumers, counterfeits can seriously damage a legitimate company's brand equity. Further, counterfeit products cost companies billions of dollars in lost sales. What can companies do to protect their brands and to fight counterfeiting? Today we'll hear from Brian Benevento, a product liability attorney at Dorsey & Whitney, LLP. He'll discuss how to establish an effective anti-counterfeiting program and the tools available to fight back against counterfeiters. Brian?
Thank you. Counterfeiting is a huge problem, and it continues to grow. The value of counterfeit goods seized rose by 38% in 2013 to over $1.7 billion. Counterfeit goods involve a broad range of products, including pharmaceuticals, electronics, vehicles, and apparel. Counterfeit products can present serious health and safety concerns. For instance, counterfeit pharmaceuticals are not tested or approved by the FDA or any other government agency. These knockoff products can contain substances that can cause serious injury, illnesses, and even death. Last year, over $18 million worth of counterfeit pharmaceuticals were seized from companies from India, and over $43 million were seized from companies from China. To protect its brand and its products from counterfeiting, companies should take several steps. First and most importantly, the company should register its trademark and its service marks in the United States to take full advantage of the laws to protect it against anti-counterfeiting. Registering the marks permits the mark owner to bring a lawsuit to prevent the sale or importation of the counterfeit product. The company should also register the marks in the countries where it does business to take advantage of their laws as well. It is important to assign a person or a department to oversee the registration and maintenance of the U.S. and foreign trademarks and service marks. Often, companies think that they have protection when their registration has truly lapsed. Next, a company needs to be vigilant in looking for counterfeit products in the marketplace, and not just in the regular brick and mortar stores, but to also look online. A company should give thought to hiring an investigator to help with that process, as well as to place some form of a contact on its webpage so customers can report any suspicious activities. If a company discovers that their product is being counterfeited, they need to identify the source of where the counterfeit is coming from. Assuming that's been done, and assuming that the company has properly registered its trademarks and service marks, a company can bring a lawsuit under the Lanham Act for infringement, unfair competition, and dilution of that trademark. In such an action, the trademark owner can elect to pursue its actual damages and lost profits, assuming that it can calculate them from the counterfeit sales, or can seek statutory damages. Statutory damages can be substantial, ranging from $1,000 to $100,000 per counterfeit product, and up to $2 million in punitive damages if the counterfeiting is shown to be willful. In addition to seeking damages, a trademark owner can seek a restraining order or preliminary injunction to stop the counterfeiter from selling or distributing the knockoff product in the marketplace. A trademark owner can also seek a civil seizure order. This is done through an ex parte proceeding, meaning that the counterfeiter does not receive notice of the process. If the court grants such an order, the law enforcement officials carry out the actual seizure. They can seize the building where the counterfeit products are being housed, freeze the assets of the counterfeiter, or they can destroy the counterfeit goods. Before seeking a seizure order, however, the company should give serious thought to the potential downsides. If a seizure order is found to be unlawful or wrongful, the company that obtained the order can be liable for substantial penalties, including lost profits, cost of goods, lost goodwill, punitive damages, and attorney's fees. Much like a preliminary injunction or temporary restraining order, a security bond is required in the event the seizure is ultimately found to be wrongfully issued. A company victimized by counterfeiting may also ask its local U.S. Attorney's Office to seek criminal penalties against the counterfeiter under the 1984 Trademark Counterfeiting Act. The trademark owner and his counsel should work closely with the U.S. Attorney's Office to identify the scope and significance of the counterfeiting. As with any criminal matter, the decision to prosecute is solely within that of the government. So the trademark owner needs to identify the uniqueness of the harm as well as any harm to the public in stopping the knockoffs. The criminal penalties for counterfeiting can include 10 years in prison, $2 million in fines against an individual, or if it's against a company, up to $5 million.
Thanks, Brian. To request a copy of Dorsey & Whitney's no-cost anti-counterfeiting checklist, follow the link on the screen. If you'd like more information on protecting your company from counterfeiting, contact Brian or visit dorsey.com/products liability. I'm Shelby Neal for Liability Watch. Thanks for watching.